What did we just witness at the Ninth Circuit Court of Appeals? This is what happens when you get two Trump-appointed judges assigned to a panel in a left-wing, left-leaning jurisdiction. They make decisions like we just saw against the California governor about the federalization of the National Guard in California, but really about states' rights, about our federalism, about Donald Trump's assault on our union. Why don't they get that right? We break it down, what happened, what should happen next, what will happen next on Legal AF, the podcast. Here's a clip.
A lot of federal courts have stood up and done the right thing, but this Ninth Circuit ruling to me was dastardly. It was disgusting what they did in this ruling. It was a 3-0 ruling in the Ninth Circuit where they issued a stay of Judge Breyer, the federal judge's order. Federal Judge Breyer is a federal judge in San Francisco. He ruled that Donald Trump federalizing the National Guard is absolutely unlawful. Judge Breyer's been a federal judge for decades. He's got senior status as a federal judge in San Francisco. And Judge Breyer made the right analysis. By the way, Judge Breyer's brother was the former Supreme Court Justice Breyer. And so Judge Breyer looks at this statute, 10 U.S.C. 12406, that Donald Trump uses to invoke the National Guard. It requires one of three things if you want to federalize the National Guard. The U.S. has to be under invasion by a foreign nation. There has to be a rebellion or danger of rebellion against the authority of the United States. Or there has to be the president being unable with regular forces to execute the laws of the United States. It's not a hard analysis. None of those things have happened in Los Angeles. 400 people were arrested in Los Angeles, and most of that took place after Donald Trump threatened to send the National Guard in. When the Dodgers win the World Series, more people are often arrested than that. 400 people being arrested, 0.003 of the entire Los Angeles population. And this was limited to like small pockets of downtown Los Angeles. Yes. Was there a guy who threw a brick at a vehicle? Yes. Arrest that guy and put him in jail. Was there people who did graffiti and vandalism? Throw those people in jail. Those freaking moron idiot criminals are not helping anybody by behaving that way at all. Were there people who were, again, behaving in aggressive and agitating? Yeah, then if they're breaking laws, arrest them. The LAPD put out statements that they had things under control. The LA sheriffs had things under control. Overwhelmingly, the protests were absolutely peaceful. Trump ratchets it up and then uses his own ratcheting it up to claim that subsection 3 applies, that he is unable with regular forces to execute the laws of the United States. That's not what the LAPD said. That's not what the sheriff said. As someone who lives in LA, these weren't mass Rodney King style riots that took place like back then. It was nothing even close. Nothing like even anything near that was actually taking place. Trump was thirsty to send in the National Guard. Now, the additional requirement under the statute, it says that it says orders for these purposes shall be issued through the governors of the state, or in the case of the District of Columbia, through the commanding general of the National Guard of the District of Columbia. So orders shall be issued through the governors. If you satisfy subsection 1, 2, or 3, any of them, then they have to be done through the governor. Why? Because the National Guard belongs to the governor. Here in California, you know what the National Guard is doing right now as we head into fire season? You know how Donald Trump talks about, they don't rake the leaves and do all that? We do. We do in California. No, Donald Trump's like, Austria is a forest city, and Austria always criticizes, Austria is a forest country. They call themselves forest land. And they criticize California. Austria is not forest land, number one. And Donald Trump changed that story, which he was originally saying Finland. And Finland people started mocking him. So then he said Austria is forest country. What the hell is he even talking about? And then our governor needs the National Guard to do things in California. There are fires taking place right now in California where National Guard assistance is needed. So that's why orders through the governors are needed. This Ninth Circuit panel, Popok, made up of 2 Trump judges, 1 Biden judge, they all agreed in a unanimous decision that Donald Trump was able to use this statute to call upon the National Guard, to federalize the National Guard, to take the National Guard away from the governor. Now, their analysis to me was putrid. What they said is, I mean, if you want to have any silver lining in this case, they said Donald Trump still is subject to judicial review. The presidency, you can't just say that we don't have to justify why we federalize the National Guard. Courts should still be able to rule on it, the Ninth Circuit said. But the Ninth Circuit looked at what federal Judge Breyer did and basically said, you're wrong, Breyer, because in issuing the stay of Breyer's order, they had to say whether they thought that the Trump regime would succeed on the merits in this case. And they said that they thought that the Trump regime satisfied subsection 3, that Trump was unable with regular forces to execute the laws of the United States. And then they said that by sending a letter from the Department of Defense to the Adjutant General, the top position in the National Guard in California, that was sufficient to satisfy the requirement that orders for these purposes shall be issued through the governors of the states, because the Adjutant General is the representative of the governor for the National Guard. So that all you have to do is basically send a memo and say, it's ours now as the federal government. We get it. And the governor gets no say if the Department of Defense sends a letter to the Adjutant General. Now, I explained everything to you. There's nothing there that I'm missing. I'm not sugarcoating I'm just literally telling you what they found. Now, I find incredible flaws, Michael Popok, in that logic.
Maybe I do.
Maybe you do. I want to hear from you. Talk about it for a few minutes. Then I want to take a break, and then I want to talk about it more, though, as well, because it deserves a lot more Popokian review.
No, I mean, I think your framework is perfect. The law that the Supreme Court precedent they relied on, it goes back to 1827, involving James Madison and the War of 1812. See how long things took to get to the Supreme Court back then? 15 years to get to the Supreme Court, talk about the War of 1812. And in that one, Madison federalized the New York militia for use in the federal war, in the War of 1812. Different statute, was different militia act. Ours is the Militia Act of 1903. And that was the Militia Act of something else. But that seemed to be the influence there. But what was really the influence is when we talk about the 10 Commandment case, is elections matter, who ends up being judges matter, and who gets pulled from the random wheel, as we saw with Judge Cannon in Mar-a-Lago and other places, matters. And so just as the Fifth Circuit, democracy and the rule of law was lucky that we pulled a Clinton, Obama, and George W. Bush judge instead of 3 Trumpers or 2 Trumpers. In the Ninth Circuit, your hometown, I've argued in the Ninth Circuit, I'm sure you have too. It's very, it can happen because it's a random wheel, but it is moderate to liberal. Trump has been trying to get more Trumpers on there. But unfortunately, when we saw the panel, we sort of slapped our forehead. Judge Bennett, who's a moderate, not as Trumpy as some people would have thought, but he did take over and lead, I think, on this. The Hawaii former Attorney General, a blue state, who deals with immigration issues and other things. Judge Miller, who's right-wing MAGA, Clarence Thomas clerk, and Judge Sung. We first had hope for Judge Sung because she was a Biden appointee, but the other problem, as you and I pointed out in separate hot takes, is she never had any judicial experience. She never was in the trenches of a district court or a state court. She just got parachuted in to the appellate court, having only been a lawyer before. When I say only been a lawyer, she was a lawyer doing civil rights and labor, workers' rights type thing. Very important person. Probably would have been better for a little marinating, a little percolating as a trial judge. Now, some people are able to make that leap. Justice Kagan of the United States Supreme Court was never a judge. She worked in the Solicitor General's office and the rest. Brilliant. I don't think anybody would question. Nobody's ever looked at one of Justice Kagan's decisions and slapped their forehead and said, oh, if she'd only been a judge before she was a Supreme Court justice. But I think I could, and we had it on Legal AF as a live feed of it wasn't just audio, it was the video too. It's like a Zoom. And you could tell that, I don't know what was happening behind the scenes, but she was, I don't want to say she's scared of her own shadow, but she certainly wasn't going to buck Judge Bennett, who was leading this and leading them. And I didn't think, and you've had different attorneys general on with you in interviews and Gavin Newsom. They could have done a better job in the advocacy role. That's speaking for somebody that's argued there. I thought they stepped into too many traps that were laid for them. I thought they conceded too much. I didn't think my best case scenario, here's what should have happened. Firstly, this was premature. The panel, in preserving their jurisdiction, should have said, you're on temporary restraining order. We don't really have jurisdiction over TROs. You have a hearing on Friday, this past Friday, with Judge Breyer about the preliminary injunction, where he's also going to look at the Posse Comitatus Act. Hold that point. I want to talk about that and some new briefing that's happening on Monday. But come back to us on Friday. We'll give you the administrative stay, but let's have a fuller record, more fulsome record, and get to preliminary injunction. So when they stepped in before, I thought, well, it's about the temporary restraining order. But then it wasn't really about the temporary restraining order. It was really about staying the entire case, subject to maybe this Posse Comitatus thing that I'll talk about in a moment. So they should have kicked the case, let the record be more fulsome. I thought what they were going to do, I got half of it right, is they were going to find justiciability, which is a fancy term for the court has power and jurisdiction to provide oversight over presidential conduct. It's properly in a court. It's not a political question. They didn't buy Trump on that. And that's been raised over and over and over again by Trump whenever he's in trouble. But then they went right to, but we're going to be highly deferential, that was their phrase, to whatever the president says in the area of the Militia Act. We're not going to find rebellion, but we do find that enough concrete pieces and bottles were thrown at federal buildings and federal officers to justify the federalization of the entirety of the California National Guard. So, just saying it out loud sounds ludicrous. There was no evidence in the record, and that's what they're supposed to be relying on. There was no evidence developed below that there was an inability of the state officials, whether it was the mayor or the law enforcement, the sheriff's department, whatever, to gain and regain control at these various locations of protest. You're right to mention the Rodney King protest in the 92s. You were a young man. I was 1 year out of law school. It was in and around the time of the O.J. Simpson. There was a lot going on in California at around that time that was very interesting. It wasn't anything like that. The state had not lost control of public safety, which should be the measure. So I didn't like that. I thought the better course for them, if they were even going to take jurisdiction, would have been to remand it back to Judge Breyer for the Friday hearing with instructions about how to develop a better record about whether the highly deferential thing should be given to Donald Trump. But no, they found there was enough in the record to support, with the highly deferential standard, Trump's finding that he couldn't faithfully execute his laws with regular forces. The open question, and I want to hear what you think is going to happen on Monday, or after Monday, is Judge Breyer pulled everybody together. He's the trial court judge. After the late ruling came out on Thursday night, and he made a joke. He said, everybody up late? Because the order came out sort of late. He says, all right. The open question for me is whether I have jurisdiction over the Posse Comitatus Act provision, which he seemed to be very concerned about, as to whether Donald Trump has the right to use the U.S. military on domestic soil, turn it inward towards Americans and others, which they did, to detain and arrest, whether that violated the Posse Comitatus Act. He wanted to get to the bottom of that with the new evidence that had been developed since his last hearing. The question for him is, when you read the order, the one line of the order, it says, and for that reason, the motion for stay is granted. Now, if you go back to the motion, it's a little bit murky as to it was over the temporary restraining order process or the order that just got granted was about the whole case. So he wants briefing filed on Monday, competing briefing, which you and I will get our hands on and post and talk about whether he's got jurisdiction to continue with the case or is the whole case on ice. I think, having read the motion and the relief sought and the one-liner in there without further clarification, that he still has jurisdiction to continue the case on the items that were not before the appellate court, because the appellate court doesn't have jurisdiction about other aspects of the case that have not yet been litigated properly by the trial court level. What do you think?
Before we went to break, you asked me a question, what I think will happen with the remaining briefing before Judge Breyer. Look, my view of it is that this Ninth Circuit panel is clearly a very unfriendly panel. I think the view that this Ninth Circuit panel will take of it, that they're shutting down this case and letting until there's a trial, which is, in some indefinite time in the future, because technically they didn't reach the merits. They just stayed the order, which allows Trump to continue to federalize the troops pending the more fulsome record and trial, which, can take a year or longer or whenever the thing will be set for trial. I think you got a bad panel. I think the panel will take a very expansive view of their order. I think that their order left much to be desired in terms of, does it stop other, to your point, does it stop other things from being invoked? But I think that I think ultimately this Ninth Circuit panel is a disaster, and they will continue to, it doesn't matter. They're going to continue to rule against Governor Newsom. Now, the challenge for Governor Newsom now is this question. Should the state of California do what's called an en banc appeal to the full Ninth Circuit of how many judges are there, Popok? 27?
There's 29. You need to get 16 to vote yes, and then they put together an 11-person panel to hear the case again.
Yeah, so I think you have the votes for that in order to get in on. I think you clearly have the votes for that. So do you go in front of basically this broader panel of judges, 11 judges, and do this en banc review? Do you try to go immediately to the Supreme Court? Or given that the Marines at the current stage and the National Guard are the bigger issue right now in LA is the ICE, is ICE and masks, and they're patrolling the streets like the Gestapo, hiding in bushes and attacking people on our streets. Like, we have a secret police force of federal officers, American citizens, migrants. It really doesn't matter. If you look Latino, they're chasing you down and they're hunting you in the streets of Los Angeles right now. I can tell you from personal experience that my mother-in-law doesn't leave her house. She's an American citizen. She doesn't go to church anymore. If she does, she has to go with protection. She's from Guadalajara. She became a citizen a while ago, but she sees it, so she doesn't leave her home anymore. And she lives in Huntington Park, which is an area that ICE goes through the streets like Nazi Germany. And if you leave your house, they find you and they tackle you and they throw you on the ground. The National Guard isn't doing that stuff. The Marines isn't doing that stuff. They're standing, and this is a point that the Ninth Circuit made, and that California conceded, was that the National Guard and the Marines are just standing in front of the federal buildings, kind of doing nothing. They just stand there. And it's sad too, because there's actually work that they need to do with wildfires and things where they need to help California. So the question for Newsom, though, is that because things are quieting down now, do you just kind of leave it there, and just, it's very unpopular. I mean, I saw the recent Reuters Ipsos poll. Americans hate what Trump's doing in Los Angeles. It's not a winning issue, despite cable news trying to gaslight us and claim that it is. Americans can separate that, yes, we need a strong border, which I agree with and everyone agrees with, but also we don't attack our own cities with invading troops from the United States. We don't disappear migrants who are not criminals off the streets, and those who are accused of crimes get due process. That's what most Americans overwhelmingly feel, and absolutely hate what Donald Trump is doing here. So do you just do nothing, or do you appeal? I think you have to appeal it, is my view. If it was my call, I think you appeal. I think you do every type of appeal. You appeal en banc, and you go to the Supreme Court, and you have to, because you have to get a decision. The Supreme Court needs to confront this, and this is a major states' rights issue as well, because it's not unique. Okay, Republicans, would you have wanted Biden to say, you know what? It looks like Texas can't do their energy grid the right way, and I see that the Governor Abbott is killing everybody in Texas because he refuses to deal with, his electric grid and he's handling everything wrong. I'm federalizing the National Guard troops in Texas who are going to patrol the streets and make sure we put up the right types of electric grid right there. Arguably, that fits into subsection 3 under a deferential reading of it. And so the question here is, when I've been hearing states' rights, there's no bigger egregious violation and encroachment on the 10th Amendment and states' rights generally than having a unitary executive rule like a dictator and steal the National Guard under the command of a governor that needs to be used by states' rights issues. I mean, I understand that on some situations, given the history of the presidency, not how Donald Trump has destroyed it, but I understand why in the past there would be some deference when presidents were actually responsible adult human beings and were supposed to be qualified for the position before Donald Trump destroyed that, to me, presumption. But there should be an equally strong presumption, if not a more stronger presumption, that you have to make the highest possible showing. The moment you steal a state's National Guard, that should be the highest showing. Why deferential? Then basically what you're saying is there's really no states' rights at all, and states don't exist. So that needs to be addressed before the United States Supreme Court. And you could be like, well, that could create bad precedent or blah, blah, blah.
I don't understand.
This issue needs to be addressed. There needs to be oral argument, and we, the people, deserve it. Because if all along all the states' rights thing was just complete bullshit, well, then go and make your argument and let the American people basically see, once again, the utter betrayal and fraud that is this federalist, right-wing, pro-dictator movement, right? All they wanted, all the bullshit that they gave us, Popok, with we're originalists, we're strict textualists, we're states' rights. Really, what y'all wanted was a Kim Jong-un style dictator because you were pissed off that the South lost the Civil War and your grandparents were whining about it up to you, and you wanted to do, that's really what this is all about. Popok, I'll let you address what you think Gavin should do, but then if you can, go right into 10 Commandments and Mahmoud, and we'll land the show.
I think you covered it well. I have a hot take that's going up over the weekend on Midas about my thought about what Gavin has to do. I don't think he has a choice. I think I'd rather have a win if we're all right, all the Ninth Circuit observers are right, that he will get his en banc and then try to get the majority of 11, the chief judge and 10 others randomly selected, which could also be from the original panel. It's better to have a win to go to the Supreme Court than a loss. But I think he's got to take it up. And then you're right, it sets up this weird battle where we're really just going to call the bluff of the ultra MAGA right wing on the Supreme Court. Because on one hand, and these are competing interests. On one hand, they're for the unitary Leviathan president, right? The total imbalance of our checks and balance system, placing the presidency well above the other two branches, including their own. And they accomplished that in many ways, including the immunity decision, which gave him that superpower in his own mind. But that competes with many of the ones on the right wing, like Gorsuch and Kavanaugh, even Roberts, are states' rights people. And so you're watching an assault of epic proportion against states' rights. I mean, the fact that they had to go back to an 1827 case involving the War of 1812 tells you how fundamental these issues are. And what are they going to do when presented with that? And I agree with you. I think we have to put them on the horns of that dilemma. When the American public deserves to hear what this United States Supreme Court has to say about it. And I wouldn't worry about, quote unquote, making bad law. Fortunately,
I'm just trying to understand this, Popok. So the federal government cannot allow women's reproductive rights because that's a states' rights issue.
Yeah,
but the federal that's where the states need to treat women like second-class citizens and decide what they do with their bodies. But the federal government can co-opt all of the National Guard and turn them into an arm of the federal government.
Welcome back. We sit at the intersection of law and politics twice a week on a podcast we call Legal AF. Ben Meiselas and me founded it 5 years ago. And then off the back of that, and with your support, your fervent support. We set up the Legal AF YouTube channel as well. But the podcast is an original. It's the OG. It's every Wednesday and Saturday at 8 p.m. Eastern Time on Midas Touch Network and on audio podcast platforms of your choice. We need some help. We're in the top rankings for audio podcasts, for video podcasts, but we need help with more reviews. We need help with more audio downloads and to grow our audience. And that's where you come in. We don't have any outside investors. We are the channel and the podcast you've been looking for. And with your help, we'll continue to grow and be a platform and a safe space for conversation at the intersection of law and politics. We're telling truth to each other so that we can tell truth to power. So until my next report, this is Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.